Hello, my name is Susan Graham, and my business is called Senior Edge Legal. Today, I'm going to do a video that describes the highlights of what's in a married trust-based estate plan. That includes not only the trust, but the wills, the powers of attorney, and so forth. So let me share my screen with you. And this is a trust that's for a married couple. It's Donald and Sally Bailey, and this would be the title page of a trust. The first thing you come across in that first notebook, and by the way, we normally these days have two notebooks for individuals who set up a trust-based estate plan. The first notebook has the trust, the wills, the powers of attorney, that kind of thing. And the second notebook has documents to coordinate titled assets with the trust and also other forms to fill out. So let me go back to this first notebook. At the very beginning, we have a description of all the documents that are used with the trust. So we have basically the trust itself and the different articles that are in there. For instance, Article 4 says what happens with the property when the first spouse dies. And if you're a single person, this information is exactly the same, except for obviously we've duplicated certain documents for the second spouse. Article 9 is who gets to be the trustee, and then when you no longer can be the trustee, the money manager of your affairs, who are the backups. We have the deed, the homeowner's exemption, so you get the break on the property taxes, a will, a registration of the trust, and financial powers of attorney and health documents. I'm going to talk about all of those in detail a little bit later. The first part in the trust notebook is also what I call a cheat sheet. It's a confirmation of the names of the people who are the principals, the grantors, Donald and Sally, as well as their backups, who they're relying on as their agents and their fiduciaries. When we do estate planning using a trust-based estate plan, one of the things we're focusing on is who has the power to grab and deal with titled assets during the lifetime of the clients, Donald and Sally, and while they're doing fine, but also what if they resign or they become incompetent or die? So that's what this short summary has. We have, again, the information about Donald and Sally and their address and phone numbers, the name of the trust, Donald and Sally Bailey Trust, dated September 5th, 2025, a listing of their children, and who are the original trustees. Then we talk about should they become incapacitated, who are the backups? Usually it's a spouse, and then we have other people if the spouse is not available. We talk about who are the backups as managers of the trust. We call that person a trustee. When one of the individuals who created it, we call him a trust creator or a grantor, dies. Normally, again, when one spouse dies, it's the other, and then they have backups in an order of priority. We have a financial power of attorney. This is who can sign untitled assets that are not in the trust name. When assets are titled in the trust name, the employee of the trust or the person who can sign those documents, we call them a trustee. For assets not in the name of the trust, the person who's the owner of those assets is the one who can sign them. But if the owner is not available, then we can use this financial power of attorney to do that. So for Donald, it's his wife Sally, and then we have these backups if she's not available. There are healthcare documents. This is who's going to talk to the doctor when you can't communicate effectively and you want to make decisions about your healthcare. So normally, again, it's the surviving spouse or the spouse, and then we have backups. And lastly, if something needs to be probated, that means we have a titled assets that's in a dead person's name. We have to submit the will to the court and say, hey, judge, appoint somebody who has the power to sign on behalf of a dead person. That individual is called a personal representative in Idaho. And so again, normally that would be the surviving spouse and then these other people. I'll talk about these documents in more detail in just a few moments. So the table of contents of what's in this first notebook is obviously the trust and the wills, the registration of the trust, the powers of attorney, and an authorization about electronically stored information. This means who can get at your Dropbox, your emails, your Facebook, that kind of thing, and health documents. So the first page of the trust This is really important. It says, what is the date of the trust? September 5th, 2025. Who's the one who set it up? And it's Donald and Sally Bailey. And what their address is, we refer to them as the trust creators or grantors. And they're also referred to as the trustees, the employees for the trust. It's a revocable trust. It says they're both the original and sole beneficiaries. And then it starts going through all the different articles. I'm only going to touch on a few of them. The first one is the name of the trust, Donald and Sally Bailey Trust. That's the name of the trust. That's on all the titled assets. And who can sign on those assets? Who's the employee of the trust? We call them the trustees. It's Donald K. Bailey and Sally M. Bailey, trustees of the Donald and Sally Bailey Trust, dated September 5th, 2025. Article 4 says what happens when the first death occurs. We pay all the bills associated with the first death, but then we say that normally it goes for the benefit of the surviving spouse. There are lots of variations, but I'm going to take the simple description in this summary video. The second death we refer to in Article 5. If you're a single person, obviously this would be Article 4. First thing we do is we pay all the, we refer to a list of personal property items. That means who gets the china, who gets the ring, who gets the gun, who gets the dining room set. It's referred to as Exhibit B. It's called a statement disposing of tangible personal property. And if you own any pets, we have a description of what happens with the pets. I'm a dog lady. I've always had dogs. I'll always have dogs. So it's important to me who's going to take care of those dogs when I'm no longer able to do that. Then we talk about, we skip a few things, and then we talk about who gets the money. In this case, the distribution to the beneficiaries, it's equally between two children. And we talk about what if that beneficiary dies before the people who created, the grantors or the trust creators, Sam and Sally, Donald and Sally. Well, if we say if the beneficiary should die prior to or during the existence of the trust or fail to survive us for 5 days without leaving issue, we have to use some legal words here. So issue means natural or adopted children. Then we say it usually goes back into the pot. When we say it lapses, it goes back into the pot. If they have children, most commonly clients say it goes to the children and it gets managed for the grandchildren until they're 30. There are studies that show young people don't really understand what's going on and aren't very smart until they're 30. What I'm talking about, they just don't have life experiences. So if you give them $500,000, good chance it's going to be blown because the law says they're grown-ups at age 18. So if they get that at 20, oftentimes it's all gone. So we say, no, it's going to be managed for their benefit, and you decide who's going to be the manager. And it can be used for paying for schooling, for insurance, for down payment on a house, for buying sneakers, whatever that individual, the trustee, deems as appropriate. When they're 30, they get the balance of the money. Article 9 is who's the trustee? Who's the money manager of this trust? Again, for a single person, this would be Article 8. It starts out, it's the original people set it up, Donald and Sally. And then it says if one of them can't do it, it's usually the other. So if one resigns, is incapacitated, or dies, it's the other one. And then when they're both gone or both not able to do it, then we start saying, okay, Sam's going to be the first one. If he's not available, then Lee. And then if he's not available, then Fred. Article 10, the character of the distributions. This is important for who inherits from you. If someone inherits $100,000 from you and they're married and they put that $100,000 in a joint account with their spouse, they've just lost the protection of it being their sole separate property. If they put it in an account in just their name, and so Sam puts it in his account, one of the children, and he lists it, Sam, a married man dealing with his sole separate property. If a divorce occurs, then his wife is not going to get any portion of the principal of that. Idaho law says all income generated from separate property is community property. That means the interest on that checking account or that savings account. So to avoid that, if his parents say all the income, rents, issues, profits, and gains and appreciation stay the separate property, then, and he has that account in just his individual name, as a married man dealing with his sole and separate property. When the marriage is over through death or divorce, and let's say just divorce, his wife will not be able to get any portion of that, including any income generated from it. So that's why it's in there. Article 11 says that they can amend this or revoke it whenever they want to. This is a revocable trust. We have a no contest clause, which says if they fight about it, they're not going to, they bring it to court, they're not to receive anything. We also have a trust protector clause in there. That means if the law should change, the federal government, the state of Idaho, or a judge changes the interpretation of a law so that some portion of this no longer works, we provide an informal way of being able to make that correction. If the people who created it, Don and Sally, are not able because they're incompetent or they're dead. Now, there are many other sections in here. That's what a lot of people refer to as boilerplate. They have to be in there to make this possible to enforce all portions of this trust. So that's why I'm not going through them. These are the portions I believe you should be concerned about. We have an Exhibit A of the assets that are listed in the trust. We never fill that out because if I filled that out for you now and you bought a new home later on, you're not likely to put it down. It doesn't really matter because what's critical is that the titled assets that you have, real property, brokerage accounts, CDs, the retirement accounts, are either in the trust name now or set to drop in automatically when you die. And that's why we spend quite a little time with you trying to identify those assets and preparing the proper documentation to have it transferred into your trust at the proper time. Exhibit B is who gets what I call your stuff. And so what you do is you write down, if you say, I give my piano, you don't say to my favorite child, you obviously say it goes to Sam. If in fact you sold that piano during your lifetime or you gave it away to someone else, you don't need to redo the list because you don't have a piano. So be sure to describe it so that somebody can figure out what it is you want. Don't say my favorite gun. If you have 5 guns, put down that proper number and identify the person to receive it. Now, the limit to this list is you cannot put titled assets. So you cannot say my car on here because that has a title. And you cannot say money. You can't say $50 on my checking account. It's for stuff, could be very valuable or just a family treasure. This is for pets. Who's going to take care of the pets? And anything you want to share with them about that. We have everybody sign a will, even though we get all the assets coordinated in this trust name. Now, or to drop in automatically when you die, what happens is I don't follow my clients around. And it's not uncommon that they've set up a trust and then they sell their home and downsize into another home. And it never crosses their mind to change the deed or when the deed is originally issued to make it in the name of the trust. And then they die. Idaho law says when a dead person's name is on a deed on real property, we have to probate that estate. Or if the cumulative value of the titled assets, again, RVs, CDs, brokerage accounts, that kind of thing, other than real property, exceed 100,000, we have to probate the estate. So that's why we have a will. Hopefully we won't ever use it, but that's why it's done. So in the will, you name who's going to be the money manager, who can handle things when somebody's dead. And we call them personal representative. And so you list out who those people are. We have what's called a pour over, P-O-U-R, over clause in the will. Pour, like pouring a pitcher, pouring water into a basin. It says, if anything has to be probated, dump it into my estate. I give my residuary estate to the person who upon my death is to act as the trustee or trustees of the trust. We have a client sign a registration and we file it at the court. It's an official document. When we file it, it will come back with a case number and a stamp up in this top right-hand corner. And basically what it says is, yes, you've set up a trust, the name of the trust, and the identifying number, that's the social security number of either one of the married couple, who are the original trustees and the backup trustees, and the date of the trust. And then again, we repeat who takes over when somebody can't handle it anymore. That is signed by both of our clients in front of a notary public. We're notaries here, so we notarize it. And we will When all the documents are signed by a client, we will keep this original and file it with the court and return it to our clients. Financial powers of attorney are essential. We call these enhanced durable powers of attorney because we've taken the form that's provided by the Idaho Code and added some more language to make it more powerful and helpful to our clients. So the first thing is Donald. I'm only going to go through the husband's documents. Donald, he's called the principal, is his power of attorney. He's naming his wife, Sally, as his first agent. And if Sally's not available, then we have Sam and then Lee and then Fred in that order of priority who can sign on behalf of Donald when he's not able to. There's a laundry list of what the power can cover. We have our clients check just this, put their initials in just this box. We don't want to cherry pick through all that because we don't know what will be needed later on. There are many other things in that trust, but that's the important part. There's the Idaho legislature also had this information that we provide with each power of attorney, what the duties of the agents are when they take over. And it reminds them how to sign things. So if Sam's the agent taking over, Sam would sign Donald K. Bailey, because that's the name on whatever this titled asset is, by Sam Bailey as agent. And it says when the agent's authority ends, basically when it's canceled, revoked, or the individual dies. The agent certification as to validity of power of attorney and agent's authority. This is when Sam would sign it when he finally uses it. So it would say, I, Sam, certify that the principal gave me this authority, and I certify that he's alive, and it became effective, and these powers of attorney become effective when they're signed. If I was named a successor agent, the prior agent is no longer willing to serve. And in here, he would say, Sam's wife is not available to serve. She's ill or incompetent, or she resigned, said she wouldn't do it. Signs that in front of a notary public. We always need health documents. Health documents are a living will, which is an end of life choice, and a power of attorney who can make health decisions for our client when they're not able to communicate effectively. Again, we've used the Idaho form and also added more language to make it more effective for our clients' wishes. So it's Donald and his birthday. Excuse me. It goes into effect when you can't communicate effectively, and a doctor is certified that you have an incurable injury, disease, illness, or condition. It's terminal. If they give you life-sustaining procedures, it'll only prolong your life artificially. Your death is imminent, or you're in a persistent vegetative state, and you get all the good drugs to be free of pain. There are three choices. One says do everything to keep you going as long as possible. That's his first one. I have done thousands of these by now, and very few people have chosen that. Some people choose this middle one, which says don't bother with the fancy stuff, but give me nutrition or try hydration or both. And that's by tubes, nose tubes, stomach tubes, out by tubes. Or say keep me comfortable, let me go. That's the most common one. There's other information in there that you can choose. One of them is medical assistance in dying. This is really assisted suicide. It's not legal currently in the state of Idaho, but it does say your agent can take you to a jurisdiction that allows this. About half of my clients, I am surprised, but about half of my clients are making this election. It's legal in 12 states. Our neighbors, Washington, Oregon, California, Montana, Colorado, they all allow it. So I'm just letting you know that's an option in there. Then when you make a choice for your healthcare agent who can talk to the doctor, again, you start with the first one, and in this case, it's Sally, the spouse, and then we go through this series of suggestions. We have Sam, and then we have the others behind Sam. So those are the most important documents that are in that first notebook. Now, the second notebook has two different parts. One is we have a whole series of documents to coordinate your titled assets so that they're either in the name of the trust now or drop in automatically when you're gone. And we have a successor trustee roadmap that I'll go through in just a moment. The asset, we do a deed for all the real property in Idaho, and we have you sign something to protect your homeowner's exemption, so you get the break in the property taxes. If you own real property outside of Idaho, we do not handle that. I'm not licensed outside of Idaho, so we have an attorney in that particular state do the deeds. These are the type of letters we provide. We provide all these letters and they're blank letters. We also, for every asset that you've given us the information, we created a letter that we send to these different companies that say, for instance, the bank letter, it says to the bank, take my checking account number 123 and leave it alone, but make it a paid on death account, POD account to the trust. So when you're gone, your trustee, your successor trustee, can go down to the bank with a certified copy of the death certificates, and the bank will write a check to that successor trustee for the money that's in that account. Now, these are ping pong games, so when we mail these letters out on your behalf, the company will normally send you back a form that they're in love with, so you just need to complete that form and then return it to them, and all your title to assets will be lined up with the trust. And there are sometimes additional assets, like for limited liability companies or partnerships. I haven't listed those, but these are the common ones we put in the documents. Now, these other forms in that second notebook, we have these forms printed out for you, and we also have them on a flash drive if you want to fill them out on your computer. These are things that many people have in the back of their mind, but never write it down. So we're trying to make it easy, not only for you, but for those people who are trying to help you or deal with your affairs when you're gone. I'm going to give you one example. People to notify. I have a college friend that we were roommates in college, and we actually lived together after college. And we still talk to one another, send notes back and forth, or emails or texts. And then we visit, every few years. She lives in Boston. The last time I visited her in Boston, she asked me, how am I going to know, Susan, that you're dead? I thought that was a good question. Highly unlikely anybody's going to notify her. So I came back and created this form. And if you looked in my address book, it's decades old. I have people in my address book who are dead. I have people in my address book, I don't know who they are. And I'm too lazy to start a brand new one. So that's no help to anybody. So this is what I'm talking about, making it easy for the people who want to help you to actually be effective when you're gone. You can ignore these, or you can fill out what you like. One I like is items to destroy, to be destroyed. I really wanted to call it my secrets, but if I called it that, that'd be the first thing everybody look at. This is for items you truly want to have destroyed. I've had clients who say, destroy all my pictures. I know I have clients who have illegal drugs or pornography or things that they just don't want the family to see or their friends to see. That's what I'm talking about. I will tell you, for me personally, when I was married, my husband went off to the Vietnam War 2 months after we were married, and I wrote to him every day for a year. Those letters are in a box, a cardboard box in my basement. And I've been divorced a long time. I don't have the courage still to open that box, but I don't want to throw it away. But when I'm gone, I don't want anyone else to open that box, and that's on my list. I want that to be destroyed. That's the kind of thing I'm talking about. Okay. That's a lot of stuff. But the reason I went through this short video is I want you to understand how this all fits together. When you have trust-based estate plan, the trust is a hub of the wheel. That's where all the important information is about how the money is to be managed for you while you're doing great. And then what happens, how is it managed when you can't do it anymore because you're incompetent or you're seriously ill? And what happens at your death? Who's in charge? Who has the power to handle things for you? And then also how are everything distributed. Now that's the hub of the wheel. All the rest is to make it work. Those funding letters, those asset transfer letters, those are part of what makes it work. The financial power of attorney is to deal with titled assets that are outside the trust. so that somebody has the power when you're not capable of signing to be able to get it into the trust and follow your wishes. Same thing on the health documents and the registration and so forth. So this was designed, and that's the purpose of this video, to give you an overview of why all these documents are required to help coordinate your goal plans so that in fact your wishes will be followed and there'd be minimum or no interference from the court system or others who have no right to be involved in your affairs. So thank you for taking the time to look at this. I hope it's been a great help to you. Thank you.